We have seen different forms of ADR, right? The basic difference between, yeah, please, last, please settle down. Please settle down. The basic difference between arbitration, mediation, negotiation, conciliation is in the arbitration, the award will be passed. First one, outcome, it won't be in your hands. That means you cannot determine the outcome of the parties. You go before arbitration, you are submitting your claims. நீங்க என்ன பண்றீங்க? Arbitration போறீங்க. போனா விட்டு you are submitting your claims. You are submitting your claims. Both the parties will come. Ultimately, what is going to happen? Adjudication is taking place. Right. That means the desired outcome, you are thinking that award will be passed in your favor, but subsequently award is passed on the opposite party. That means you cannot determine the desired outcome of the process. Arbitration ఏం జరుగుతుంది అంటే end result ని you cannot determine the end result. இப்படிதான் இருக்கும்னு சொல்லி ஆர்பிட்ரேஷன்ல டிசைட் பண்ண முடியாது. Why? It's an adversarial adjudication process. Adversarial non-consensual adjudication process. That means whether you like it or not, you have to accept the award. That's it. But in negotiation, mediation, conciliation, what is going to happen is you can dictate the desired outcome. புரிஞ்சிருக்கா டிஃபரன்ஸ்? ஆர்பிட்ரேஷன் என்ன நடக்கும்? ஆர்பிட்ரேஷன்ல நீ போற, ஃபார் எக்ஸாம்பிள் A is going, B is going. Award is only in favor of one person. One person. Other person is thinking that award will be in favor. Subsequently, award won't be in his favor. But mediation, negotiation, conciliation la you can dictate the desired outcome. That means terms and conditions are favorable to both the parties. ரெண்டு பேருக்கும் ஃபேவரபிள் அவுட்கம் இருக்கும். தட் மீன்ஸ் இது மாதிரி இருந்தா நாங்க ஆக்செப்ட் பண்ணுவோம்னு சொல்லி you are telling. That means you can dictate the outcome of the adjudicatory process. So mediation is conceptually defined as an assisted decision making process. So here mediator is only assisting you in making a decision. You understand? You are going before mediation, conciliation. The decision maker is merely assisting you to arrive at a what is called conclusion. ఒక ప్రాసెస్ కి రావడానికి హెల్ప్ చేస్తాడు. Then it is up to you whether you have to accept the decision or not. If it is amicable to both the parties, they will accept the decision. That means the desired outcome you are dictating. మా ఇద్దరికి ఒప్పుకుంటే మేము చేస్తాము, లేదంటే subsequently recourse is always open to you. So mediation is conceptually defined as an assisted decision making process which typically takes the form of a facilitated negotiation or dialogue. It's a facilitator. That means adjudication irukadinga. Simply he will make you to sit. These are the terms and conditions. These are the applicable rules. Applicable law apply to you. You have to make the decision within the set framework. ఈ framework లోపల మీరు ఏం చేయాలి? డెసిషన్ తీసుకోవాలి. Once you accept, you are entering into a binding agreement. Here nobody is authenticating your agreement. Arbitrator who is authenticating? Arbitrator signing the agreement. Here conciliator or mediator is not the fan. Yes, you are. Thank you. Thank you. Yeah. Thanks. Right. For me, AC. For you, no AC. Only fans. Huh? Only fans. అది కూడా తిరగట్లా. Right. Yes. No, it's good. At least some people are listening to my lectures. At least some people. It's very good. That means change is happening in you. Change is happening. This change should be permanent change. எப்பவுமே ஒரு ப்ரொஃபஷன்ல என்டர் once you enter into the profession, so many constraints will be there. So many constraints. That means you are entering into the profession, you have to learn a lot in the process. 8 varsham, for 8 years, I worked without money. Not even a single pie. Yes, not even a single pie. Eppadi? Still, I remember those days. I fought with the auto driver for 1 rupee. ஆட்டோ டிரைவர் ஆட்டோவில் ஏறி ஹைதராபாத்தில் ஷேரிங் ஆட்டோஸ் இருக்கும், 2-3 ஆட்டோஸ் இருக்கும். ஏறி போகிறப்ப அவன் 2 rupees கொடுக்க 1 rupee கொடுக்கல, அவனோட சண்டை போட்டேன். 8 வருஷம் 8 years without any money. I worked 8 years in Hyderabad. Only weekly 200 rupees. My brother-in-law used to give me. My brother-in-law is a young chartered accountant. Hyderabad எனக்கு தெரியாது. I don't know Hyderabad. My boss, he asked me, if there is Nampalli court is there, you go. Rangareddy court is there, you go. Where I go, I don't know Hyderabad. But I don't know Hyderabad is a big city. Now, sir, I don't know Hyderabad, I don't know. Then he said, you are having court? No. Yes, I am having court. Where that court first? Yes. You are having, at that time I am having kinetic Honda. Right. You wear the coat, go. No police will stop you. Right? You can bypass signals also. You ask and go. That's it. No, that is how I started my things. 8 years, not even a single pipe. Right. Now what happened? After 8 years, somehow you have to marry at some point of time. Some point of time, you have to marry. Let it be 25, 30, 35, 40, 45. I think one of my student is craving for marriage. He is crossing 40. Yes. Where is he? He will Mohan Raj. Mohan Raj vandana? Varle. Irukkan. Right. Right. No. The basic thing என்னன்னா அட்வொகேட்டுக்கு பொண்ணு கொடுக்க மாட்டா. ஆமாவா இல்லையா? Yes, that is universal truth. Game Raja Naidu. Advocate, yeah, please. No girl for advocates. Right. Vice versa also. Vice versa also. For you, no girl. For them, no girl. Only option is you have to marry an advocate only. Right. That is the option left for you. For me also, no option. I married an advocate. No, it's a satirical sense. Right. No. This is how you have to start your things. It will test your profession. But I enjoyed 8 years without money. Happy. 200 rupees per week. I used to have a happy enjoy. Then money, after earning the money, problem starts. Yes. காசு இல்லாதப்போ happy days, happy life. Once you will get the money, problem will slowly starts. Like, no, no, I am not telling that, but change is there. It's appreciable. Have the positive side on the things always. For every side of the coin, two sides will be there. Always see any situation only positive side. That's it. Just see the positive side. Just go on. Right. Now, so the mediator assists the parties to make decisions about the issues in dispute between them and about the appropriate norms for the regulation of future relationships. He will only assist. That's it. He will tell if you follow, both the parties will get favorable result. He is not dictating the desired outcome whether you like it or not. Simply he will assist. Then once if you accept for that, you enter into an agreement to follow those things. Subsequently, as usual, when you sign an agreement, Indian Contract Act will come into picture. If any party bypasses it, other party can go and file a petition in normal courts for specific performance. Right. So generally, mediation is based on principles such as party autonomy and parties are free to choose the methodology, free to choose the laws applicable, free to choose everything. Everything. If you don't like, just go out. Both the parties are coming, they are choosing. Right? Next one is client centeredness and choice. So it revolves around your dispute only. It revolves around your dispute. Arbitrator, sometimes he will follow the law, courts will follow the law. Here, everything revolves around the center of dispute, that is you only. Idu unga dispute, we are going to adjudicate. If you like it, you pass a what is called sign an agreement, you follow those things. Confidentiality, right? And a focus on interest and needs rather than rights and positions. So here there is no such a thing as your rights or position, right? Simply they are focusing on your interest. நீ யாரு நீ என்னன்னு சொல்லி எல்லாம் ஒன்னும் இருக்காதுங்க, இக்கடேமி ఉండదు. Straight away what they are going to do, you sit, make an amicable settlement. If you are interested, you can sign a binding agreement. The process is voluntary. So voluntary you are going. For example, under the Industrial Disputes Act, if any dispute has arisen between employer and employee, employee and employee, employer and so, first what is going to happen? You will be referred to conciliation. Conciliation. இப்போ conciliation நீங்க accept பண்ணணுமான்னா, there is no mandatory provision that you have to accept for that conciliation. Simply he will make you sit. He will make you sit. Tell the pros and cons of the outcome. If you enter into this, if you get these results, right? The process is voluntary. So far as parties are not required to make any decisions or to reach agreement, right? The decision you are making is reflected by your choice and priorities only. நீ எந்த decision எடுக்கிறியோ, that is reflected in your choice and priorities. Why? There is no adjudicatory process. You are accepting as per your convenience. We are going to what is called assist you. We are not passing anything. We are going to assist you. The process is voluntary insofar as parties are not required to make any decisions or to reach agreement, right? Insofar as decisions are made, they are said to reflect the parties' choices and priorities, right? So many again mediation centers are there throughout different institutions are there, like institutional arbitration, individual arbitration, institutional arbitration, mediation centers are also there. You can go for mediation, high technical persons will be there, you can get your dispute resolved, right, within a short span of time. That is binding on you. Why? Because you are entering by consensual consensus ad idem. You can go for mediation. Even big international companies are there, without going for arbitration they can select for mediation. This is another mode only. Yes, speedy disposal of the cases. Compulsory arbitration ke ponumana teva kadiyadu. You can go for any mediation, conciliation, negotiations. Again, scientific rule will come into picture. Scientific rule, theory of probability is there. Kelipattirukangala? Theory of probability is there. Statistical methods will come. Whoever is mediating, negotiating, simply he won't make you to say it and what is tell this is the things. Probability solano. Probability anna, suppose chess daayam untundi kada, 10 సార్లు 10 వాటి పోట ఎత్తన వాటి ఇది వరుణ్ சொல்லுவா. அது என்ன சொல்லுவான்னா theory of probability. Yes, in mediation negotiation probability test will be there. Another test is also there, chi square test. Statistics la chi square test nu test irukum. இதெல்லாம் ஏன் போடுவான்னா இது மாதிரி டெசிஷன் பாஸ் பண்ணா இது மாதிரி ரிசல்ட் வரும் உனக்கு. They will analyze different ways in which your outcome will be there. If you sign this agreement, this is going to happen. If you go for A, this is going to happen. If you go for B, this is going to happen. Different scientific analysis, investigation they are going to make. Simply don't think that you are going before what is called mediation. He will ask you what is your problem. He will ask you what is your problem. Settle. போலீஸ் ஸ்டேஷன்ல போனா தெரியும்ல, அவனை கூப்பிடுவான் இவனை கூப்பிடுவான், என்னவும் ப்ராப்ளம்னுவான், காசு வாங்கிக்கான், கோ தட்ஸ் இட். அதுதான் மீடியேஷன். அதெல்லாம் மீடியேஷன் கிடையாது. அதெல்லாம் that is not the mediation in technical terms, right? So many scientific methods, investigations will come, right? For example, you have to know all these sort of things. For example, if you get a medico legal case, what you have to tell to the client? ஒரு మెడికో లీగల్ కేస్ అని தெரியுமா? ఒక పెద్ద మెడికల్ కేసు వచ్చింది మీ దగ్గరికి, అప్పుడేం క్లయింట్ வருவான், சார் எனக்கு கால் எடுக்கிற பதில் கை எடுத்துட்டான் டாக்டர், காம்பன்சேஷன் வேணும்னு சொல்லி வருவான். கிளைண்ட்ஸ் வருவான். இட்ஸ் கேஸ் you have to file. Then what you have to tell? I am only law student, I don't read, I didn't read. Yeah, medicine தெரியாது எனக்கு சொல்லுவாங்களா? Again what you have to do? Study. Yes, படிக்கணும். Yes, lawyer should know everything. But no, it's one case has happened which has reached Supreme Court. One person went to the doctor, actually he is having some leg pain. Left leg pain is there for him. He went to the doctor. I think he fought with his wife. Instead of amputating left leg, he amputated right leg. Yes. ఏదో చేసేసాడు. మొన్న రాత్రి వైఫ్తో గొడవ పడినాడు, నిద్రపోలేదు. He has amputated. Ultimately, he was bedridden. His back, yes, it's case. Bedridden forever. Then he went and filed a case in first hierarchy is district consumer forum, right? What is called the relief claimed plus your everything, there is pecuniary jurisdiction will be there. District forum, he went and he is asking for more than 1 crore at that time. It's a reported case in Supreme Courts, right? Now district forum has awarded some amount. Then he went on appeal to State Consumer Forum. Right. There also they have slightly enhanced the compensation. But he is asking for more. Why? My entire life has been what is called smashed. Now I can't work. Normally, how the courts are giving you the compensation, they will take your age, multiplying by your earnings. ஒரு ஃபார்முலா இருக்கும். ஒரு மோட்டார் வெஹிக்கிள் ஆக்சிடென்ட்ல நீங்க இறந்து போனீங்களா ஒரு ஃபார்முலா பிரகாரம் தான் கொடுப்பா. Again, they have slightly enhanced. Then the case went to National Consumer Forum. Again, National Consumer Forum has confirmed the State Consumer Forum. Subsequently, he went to Supreme Courts. Supreme Courts. Now, you know the jurisdiction of the Supreme Courts. Supreme Court jurisdiction anna unlimited. Unlimited jurisdiction of Supreme Court. Let it be peculiar. Even sometimes Supreme Court is having extraterritorial jurisdiction also. Extraterritorial jurisdiction. It can assume it. Subsequently, his compensation was enhanced from 30-40 lakhs to more than 3 crores. More than 3 crores. Now, no, this is the area. That means you have to know everything about everything. Again, of course, Supreme Court judges, they'll take the assistance of the medical experts. Expert opinion is there. So on, so. Ultimately, they have been awarded more than 3 crores. No, this is how the things will going on. Lawyer Anna, every situation you have to analyze, read. Fact is different, law is different. Fact is different, law is different. Sometimes if you tell the law wrongly and basing upon that thing, if the court passes an order, that is not binding on you. You are telling court, don't think that court will know everything. Erroneously, by your things, the court has passed an order basing upon your law, then it is not binding on you. Understand? There is, I think I told you in the Evidence Act this thing. Right. Now, let's go into the class. So, insofar as decisions are made, they are set to reflect the party's choice and priorities. Mediation is a facilitative process in which disputing parties engage the assistance of an impartial third party. They are engaging in one person, he is an impartial third party. The mediator who helps them to try to arrive at an agreed resolution of the dispute. Right. Now, the mediator has no authority to make any decisions that are binding on you. தெரியுமா? மீடியேட்டருக்கு அத்தாரிட்டி இருக்காது. ஏதாவது டெசிஷன் கொடுத்தா அது உங்க மேல பைண்டிங் ஆகுமான்னா ஆகாது. ஆர்பிட்ரேஷன்ல ஆகும். That is binding on you. Why? Again, arbitrator is deriving his authority by your agreement only. Right? Once he gives the decision, his mandate will be terminated. ஒரு பவர் உனக்கு வராத நீ ஒன்றும் பண்ண முடியாது. You understand? For example, in company board of directors will be there. Guys, who is giving power to board of directors? Shareholders. Companies Act. Companies Act will give power. Very good. Next. Memorandum of Association, Articles of Association, right? Third one is there. Shareholders Resolution. Fourth one is there. Agreement entered into by the company and the board of directors. You understand? Fourth, unless and until power has been given to you, you cannot exercise that power. Right. The mediator has no authority to make any decisions that are binding on them. but uses certain procedure. Procedure means scientific procedures, chi-square test, theory of sampling, probability sampling, so many he will use techniques and skills to help them to negotiate and agree resolution of their dispute without adjudication. There is no adjudication. Adjudication irukadu. Simply he will assist you. In arbitration, adjudication will be there. Right. Mediation, it is a negotiation carried out with the assistance of a third party. The mediator, in contrast to the arbitrator or judge, right, has no power to impose an outcome on disputing parties. Right. Previously, judge or arbitrator, they will be having the teeth ante enti ante pattukuntaru itla. That means they can dictate the outcome of the process. Here, mediator lacks the teeth in the mediation process. The involvement of mediator alters the dynamics of negotiators. Simply, he will alter the dynamics of the outcome. If you go in this way, for example, if you go in this way and if you get any agreement, this is against law. ஸோ இது செல்லது, இது செல்லாதுன்னு சொல்லி அவன் என்ன சொல்லுவான்னா, இது மாதிரி தான் நீங்க போகணும்னு சொல்லி சொல்லுவான். He will alter the dynamics, but he cannot alter the outcomes. You understand? He cannot dictate the outcome, but he can alter the dynamics. If you go in this way, this is the law prevailing. Presently, this is the law prevailing. If you are going under this law, you will get it. So, depending on what seems to be an impeding agreement, the mediator may attempt to encourage exchange of information, provide new information, help the parties to understand each other views, right? Again, emotions are also be taken into account here. Emotions also provide new information, help the parties to understand each other views, let them know that their concerns are understood, promote a productive level of emotional expression. யாருக்குமே ப்ராப்ளம் இல்லாத ரெண்டு பேருக்குமே ஒரு amicable solution. Deal with differences in perceptions and interest between negotiations and constituents, including lawyers and clients. Lawyers and clients, they are nothing but negotiators, some type of mediators. He will tell, if you go to the court, time will lapse. Better go for arbitration. Better go for conciliation. కోర్టుకి వెళితే టైం అవుతుంది, సో మీరేం చేస్తారు, go before arbitration. He is telling you time will be saved. Help negotiators realistically assess alternatives to settlement, learn about those interests the parties are reluctant to disclose to each other, and invent solutions that meet the fundamental interest of all the parties. The main thing is he will make you to arrive at a amicable solution. మీరు ఎలా అంటే అలా మళ్ళీ అగ్రిమెంట్లోకి ఎంటర్ కాకూడదు. ఎప్పుడన్నా அப்படி అగ్రిమెంట్లో நான் ரெண்டு பேரும் ஃபாலோ பண்ணிக்கிறோம்னு சொல்லி you cannot enter into an agreement again. All agreements, you know, are not contracts, but all contracts are agreements. Again, public policy will come into picture. Uday, sleeping, right? It's your fundamental right, subject to reasonable restrictions, right? Uday is sleeping, then somebody I know who is sleeping in the class. Yeah, I will wake them, don't worry. அர்த்தம் கால் நைட் அவுட், நைட் எல்லாம் படிச்சியா, என்ன படிச்சா? No, he's sleeping. Right. Remaining we'll see tomorrow. ఇప్పే అడిగారు క్లాస్ ఇన్సాల్వెన్సీ ఇంకా చేయాలి ఇది లైవ్ పోతాం How many honors are there? Yeah, right, good number. Yes. Yesterday I skipped the class. So today I am going to right. Just have some 5 minutes break, then I will start. Only 5 minutes. But you cannot go out, only you can relax in your seats. You cannot go out, no phones. No phones. Huh? Right. Yes. Shall I go? என்னது இன்டர்னல்ல மார்க் வேணும்னா பிரேக்கா ரைட் யா ப்ளீஸ் யா லிசன் யா ப்ளீஸ் எப்பவுமே you have to challenge your limits first. Try to understand difficult terminologies. ஒரு ஜட்ஜ் முன்ன பேசணும்னா நிறைய இங்கிலீஷ் வரணும், நிறைய லாங்குவேஜ் வரணும். You have to, 7 lamps of advocacy is there. You have learned 7 lamps of advocacy, and 8th lamp is also there. What is 8th lamp? Huh? Tact. Who told 8th lamp? Who told 8th lamp? ఎవరు చెప్తున్నారు లెసన్ లో? Krishna Iyer. I am telling 9th lamp. Why? When Krishna Iyer, Justice Krishna is telling, you are listening. When I am telling line, you don't listen, huh? 9th lamp is cunningness. Cunningness should be there in the courts. Yes, cunning means again not destructive cunningness, constructive cunningness. Now you tell me how many lamps of advocacy are there? Very good, but don't write in the exam. Speakers are told 9th lamp cunningness. Right. Everybody has to pass it. Right, we'll go. Now you know the structure of insolvency resolution process. So first what is going to happen? Corporate, what is called financial creditors, operational creditors, corporate debtor, they go, right? Application is filed. Once an application is filed, before the adjudicating authorities, they will appoint an interim resolution professional, right? What the interim resolution professional is going, he is doing two things. One is he is appointing committee of creditors. Second one is he will prepare a resolution plan. The entire thing is to resolve the process, right? Now if the resolution plan has been failed or due to some reason, ultimately what is going to happen is the NCLT passes an liquidation order, right? This is, yeah, please listen, please listen. Right. Now liquidation order will be passed. This will be passed as a last resort. ఒకసారి వీళ్ళు NCLT కి వెళ్ళి అప్లికేషన్ ఫైల్ చేస్తారు. దేనికి ఫైల్ చేస్తారు? కార్పొరేట్ ఇన్సాల్వెన్సీ రెజల్యూషన్ ప్రాసెస్. ఇప్పుడు అప్పుడు ఏం జరుగుతుంది అంటే ఇంటరిమ్ రెజల్యూషన్ ప్రొఫెషన్ ని అపాయింట్ చేస్తారు. అపాయింట్ చేసిన తర్వాత అతనేం చేస్తాడు అంటే కమిటీ ఆఫ్ క్రెడిటార్స్ ని అపాయింట్ చేస్తాడు. వీళ్ళ ద్వారా ఒక రెజల్యూషన్ ప్లాన్ ప్రిపేర్ చేస్తాడు. ఒక ప్లాన్, ఒక స్కీమ్ ఆఫ్ కాంప్రమైజ్ యూ క్యాన్ సే. ఈ స్కీమ్ ఆఫ్ కాంప్రమైజ్ ప్రిపేర్ பண்ணி திருப்பி யாருக்கு கொடுக்கணும்னா again it has to be approved by the adjudicating authority, right? If due to some reasons it has not been approved, ultimately liquidation order will be passed. Then in the place of interim professional, official liquidator will come. రెండు స్టేజ్ పారు. ఫస్ట్ స్టేజ్ లో ఏమో ఇంటరిమ్ రెజల్యూషన్ ప్రొఫెషనల్, ఈ స్టేజ్ లో ఏమో అఫీషియల్ లిక్విడేటర్ విల్ కమ్ ఇన్ టు పిక్చర్. వాట్ ఈస్ గోయింగ్ టు డూ? He will take all the assets, sell the liabilities, completely wind up the company. He will tell the adjudicating authority that company has been wound up, dissolved. Then NCLT will possess an order that company has been dissolved. Take this order, go on file with registrar of companies. Then your company's legal existence will come to an end. If a company ennachu இன்னும் ஒண்ணுமே கிடையாது. The company started its legal existence by operation of law, end the company by operation of law. Final అయిపోయింది ఇంకా. Now under what circumstances a liquidation order can be passed? The normal thing is NCLT never ever passes a liquidation order. Only certain criteria is there. Entire object of insolvency and bankruptcy code is not to wind up the companies. Understand? Not to wind up the companies. Section 33 of the code lists out the triggers for initiating the liquidation process for corporate persons. I am insisting on corporate persons, not individual person. Again, that is separate is there. Individual insolvency, in the place of official liquidator, bankruptcy trustee will come. Bankruptcy trustee வருவான். எங்க வருவான்? இண்டிவிஜுவல் இன்சால்வென்சில, பார்ட்னர்ஷிப் இன்சால்வென்சில. இங்க வந்து யார் வருவான்னா அஃபீஷியல் லிக்விடேட்டர் வருவான். பொசிஷன்ஸ் வில் சேஞ்ச், ரைட்? பட் எல்லாருக்குமே, ஃபார் எக்ஸாம்பிள், இஃப் எ கொஷன் இஸ் ஆஸ்க்ட் ஆன் ரைட்ஸ் அண்ட் டியூட்டிஸ் ஆஃப் பேங்க்ரப்சி ட்ரஸ்டி, you have put the heading bankruptcy trustee and write liquidator. No problem. Ideda more or over same functions will be there. Where the adjudicating authority, before the expiry of the insolvency resolution process, before expiry of the insolvency process, that is how many days? 180 days. 180 days குள்ள என்ன பண்ணணும்? ரிசால்வ் பண்ணணும். பண்ணலன்னா என்ன பண்ணுவா? ஒரு வாட் எக்ஸ்டென்ஷன் இருக்கு. ஒன் டைம் எக்ஸ்டென்ஷன் இஸ் தேர் 90 days or the maximum period permitted for completion of the corporate insolvency resolution process. Permitted period within 190 days or extension of 90 days or the fast track corporate insolvency process. Fast track இது இன்னும் வரல. ஃபாஸ்ட் ட்ராக் சொன்னேன் நான். ஐ டோல்ட் யூ ஃபாஸ்ட் ட்ராக். வெரி குட். 90 plus 45 days. 90 plus 45. Fast track also resolution professional will be there. As the case may be, in the time kulla adjudicating authority does not receive a resolution plan. You understand? What is the first criteria? No. Show some maturity. You are all grown up children. Somebody is there taking your phones. அது உங்களுக்கே ஒரு இதுவா இல்ல? இல்லையா? இருக்கா இல்லையா? All you are all grown up. Maintain that perspective இருக்கும். If you are having that perspective, you can tell other persons to have their perspective. I tell you a live example. When I went to Hyderabad and I came in the midnight, early morning, 3 o'clock, I reached the bus stand. 3 o'clock in the morning. 3 maniki bus stand la erangina, one auto driver has come. Then normally I have a habit, nee yaru, what is your background? I used to ask. How many children are there? How many you are having? I mean children, so on, so on, so. Right. Then he said, then I spoke, it said, then I asked him, why you are coming? What is your time? He said, sir, morning 2:30 I will come here, sir. By 9 o'clock I will end my session, go to home for sleep. Then I asked him, why you are not coming in the morning? Why you are coming in the early morning, 3 o'clock? He said, 3 o'clock ana auto drivers நிறைய இருக்க மாட்டா பஸ் ஸ்டாண்ட்ல எனக்கு ஏதோ கொஞ்சம் காசு கிடைக்கும். That's why I am coming early morning 3 o'clock. Then slowly he said, my father, when I was studying, he used to tell me, wake up 3 o'clock in the morning, study. 3 மணிக்கு எழுந்து படி, உன் லைஃப் நல்லா இருக்கும்னு சொன்னான். அப்ப என்ன பண்ண, అప్పుడు ఏం చేశాను, 3 గంటలే చదవలా. ఇప్పుడు నాకు ఇష్టమున్నా లేకపోయినా ఏం చేయాలి నేను ఇప్పుడు 3 மணிக்கு எழுந்து ஆட்டோ ஓட்டணும். அப்போ 3 மணிக்கு படிச்சிருந்தாக்கா இன்னைக்கு நீ என்ன பண்ணிருப்ப, வீட்டுல தூங்கின்னு இருப்ப. அன்னைக்கு தூங்கின இன்னைக்கு ஆட்டோ ஓட்டு. You understand? That day you slept for, you are wasted your life. Now you are coming. ఇప్పుడు నువ్వు వినుంటే ఆ మాట, ఇంట్లో హ్యాపీ ఏసీకియా తూంగ్. దట్ ఈస్ నో, దిస్ ఈస్ ద థింగ్. యూనివర్స్ ఈస్ ది బెస్ట్ చార్టర్డ్ అకౌంటెంట్. ఇట్ విల్ అసెట్, యూ విల్ బ్యాలెన్స్ యువర్ లయబిలిటీస్ అండ్ అసెట్స్. எக்ஸாம் எழுதாத கடவுள்ல போய் சாமி நான் பாஸ் ஆனோம்னா பாஸ் இல்லை, ஃபெயில் தான். எக்ஸாம் நல்லா எழுதி கடவுள்கிட்ட போகாதனால என்ன ஆகும், பாஸ். யுவர் ஆக்ஷன் இஸ் யுவர் காட், தட்ஸ் இட். நீ எந்த கடவுள் கிட்டனாலும் போ, நோ யூஸ். யூ அண்டர்ஸ்டாண்ட்? யுவர் ஆக்ஷன் இஸ் யுவர் காட். வாட் எவர் யூ டூ, யூ வில் கெட் இட் இன் தி சேம் ப்ரப்போர்ஷன். இன்னும் நிறைய கூட வரலாம். Even you will get it more also. That is the law of Newton's third law. For every action there is a opposite equal reaction. அவ்வளவுதான். இதுதான். That is your action is your God. இன்னைக்கு நீ படிச்சா நாளைக்கு ஏசிக்கியா தூங்கலாம். இல்லைன்னா என்ன பண்ணணும், 3 மணிக்கு எழுந்து ஆட்டோ ஓட்டணும். That does not mean that you what is called drive the auto. Compulsion makes you like this. If you don't read at the time of reading, then you will be left with no option. Left with no option. You have to look after your family. He is telling his children the same story. అతను ఏం చెప్తున్నాడో అవన్ పసంగని சொல்றான், 3 மணிக்கு எழுந்து படி, இல்லப்ப நான் மாதிரி ஆட்டோ ஓட்டுறேன்னு சொன்னோம். No, this is how. So once if you get into this profession, it will test your patience. You understand, right? Again coming to ஞான சௌந்தர்யா, புரிஞ்சிருக்கா இல்லையா? எங்க பாக்குற, எங்க பாக்குற, யாரு பாக்குற, எங்க பாக்குற, யாரு பாக்குற, போர்ட பாக்குற, என்ன பார்க்கலையா? Right, right. So within the time limit, NCLT don't receive resolution plan. First criteria, let it be fast track insolvency or normal insolvency. Second one, it has received the plan, but it rejects the resolution plan. It has received the resolution plan, but NCLT has rejected the resolution plan for non-compliance of the requirements specified therein. Right, two things. If you don't receive or after receiving, it is not in compliance with so and so section. Pass an order requiring the corporate debtor to be liquidated. So it will pass an order for winding up. Again, once winding up order has been passed, subsequently it cannot be revoked once again. You cannot resume back to corporate insolvency resolution. திருப்பி அங்க பின்னால போக முடியாது. ஒரு வாட்டி liquidation order pass ஆயிட்டனா, again you can challenge in NCALT Supreme Courts only. It cannot revoke or review its own order. Right? Right. So liquidation order pass panna udane enna solluvaanna issue a public announcement stating that corporate debtor is in liquidation. Public announcement. Here no moratorium will be there. Only public announcement. You know why? Liquidation has been in progress. Every stakeholder has a claim in the company. Every stakeholder has a claim. Company stakeholders இருப்பா அவங்க காசெல்லாம் கொடுக்கணும் இல்லையா? அப்போ ஒரு பப்ளிக் அனௌன்ஸ்மெண்ட் பண்ணி this company is going into liquidation. If any stakeholder is having any claim against the company, please submit your claims. Let it be a, I am not using the word shareholder. I am using the word stakeholder. Government is also a stakeholder. அவங்களுக்கு tax varno, debenture holder is a stakeholder, investor is a stakeholder, banks, finance institutions, whoever has given the money, they are all interested in the company. They are known as stakeholders. So you have to submit before the prescribed date. Again, if the date has been over, your claims won't be settled. You understand? Okay, time is there. One time will be given. Within this time, you have to come before the liquidator. Submit your claims. Once time limit has been lapsed, subsequently you cannot claim. அப்புறம் claim பண்ண முடியாது. That's why the main idea or theme behind the public announcement. You understand? Next, require such order to be sent to the authority with which the corporate debtor is registered. You understand this point? Require such order to be sent to the authority with which the corporate debtor is எந்த அத்தாரிட்டிக்கு ரிஜிஸ்டர் பண்ணங்களோ அந்த அத்தாரிட்டிக்கு நோட்டீஸ் அனுப்புவா. ஃபார் எக்ஸாம்பிள், if it is a company, registrar of companies, it is NBFC, under which act it has been registered, registering authority. Cooperative societies, cooperative registrar will be there. Societies Registration Act, societies registrar will be there. ఏ అథారిటీ కింద మీరు దాన్ని రిజిస్టర్ చేశారో వాళ్ళకు కూడా ఏం చేస్తారు అంటే ఒక నోటీస్ పంపిస్తారు. యు నో వాట్ ఈస్ ద పర్పస్? దే విల్ స్ట్రైక్ యువర్ నేమ్ ఇన్ దట్ రిజిస్టర్. ஃபார் எக்ஸாம்பிள், கம்பெனி ஹாஸ் பீன் wound up. ஆர்ஓசி என்ன பண்ணுவான்? ரிஜிஸ்டர் ஆஃப் கம்பெனிஸ்ல உன் பேர் என்ன பண்ணுவான்? ஸ்ட்ரைக் ஆஃப் பண்ணுவான். Societies registrar will strike off your name. So require such order to be sent to the authority with which the corporate debtor is registered. Where the insolvency resolution professional at any time during the corporate insolvency resolution process, any time during the corporate insolvency resolution process, but before confirmation of resolution plan, before confirmation resolution plan by the adjudicating authority, intimate the adjudicating authority of the decision of the committee of creditors. Here, even committee of creditors can take a decision to wind up the company. புரிஞ்சுதா? கிரெடிட்டார்ஸ் கூட என்ன பண்ணலாம்? கம்பெனியை வைண்ட் அப் பண்ண சொல்லி கேட்கலாம். You know, you can start the company, but if you want to wind up the company, it is not in your hands. Court has to pass an order. So, during the process of corporate insolvency resolution process, before submission and confirmation of resolution plan, resolution plan submit பண்ணிட்டா விட்டு திரும்பி கேட்க முடியாது. Before, right? The decision of the committee of creditors approved by not less than 66% of the voting share to liquidate the corporate debtor, the adjudicating authority shall pass a liquidation order. Committee of creditors இருப்பா இல்லையா? Who will constitute committee of creditors? Normally financial creditors only. Committee of creditors அவங்க தான் இருப்பா. ஒருவேளை ஃபினான்ஷியல் கிரெடிட்டார்ஸ் இல்லைன்னு நினச்சிக்கோ, Remaining creditors can form the committee of creditors. Operational creditors can form the committee of creditors, right? Next, when liquidation can be ordered, right? We will see where the adjudicating authority does not receive a resolution plan before the expiry of the corporate insolvency resolution process or fast track insolvency process. Again, there is another process is also there. Fresh start process undi malli. Fresh start process is there. Yes, after this I will take fresh start process where the adjudicating authority rejects the resolution plan for non-compliance of the requirements or where at any time before the confirmation of the resolution plan, including at any time before the preparation of information memorandum. Information memorandum, if you remember Companies Act, liquidator will prepare one thing, statement of affairs. Remember, in the liquidation process, statement of affairs prepare பண்ணுவோம் எங்க Companies Act ல winding up ல இங்க என்ன பண்ணுவாங்கன்னா information memorandum. So, at where at any time before the confirmation of the resolution plan, including at any time before the preparation of the information memorandum, committee of creditors resolved to liquidate the corporate debtor, right? Now, another thing is, once the resolution plan has been approved by the adjudicating authority, subsequently it has been contravened by the corporate debtor. Resolution plan approve panna vittu ata corporate debtor enna pannano follow cheyali. అతను ఫాలో చేయకపోయినా కూడా ఏమవుతుంది, liquidation order will be passed where the corporate debtor contravenes the terms of the resolution plan. So these are the grounds. First ground is within the time limit NCLT don't receive the resolution plan or it receive resolution plan but violates in terms of the compliances, committee of creditors can also apply for what is called liquidation or corporate debtor contravenes the terms of the resolution plan. Now, who is going to take the company's affairs? Liquidator. இப்போ யார் வருவான் pictureல? Liquidator will come. He will take all the assets and liabilities. Before the liquidator, who is handing over the company? Interim resolution professional or final resolution professional. Now he will come. Again, he is having more powers than interim resolution professional. You understand? During the corporate insolvency resolution process, there is one aspect is their moratorium. Moratorium என்ன நடக்கும்? Company previous suits எல்லாம் stay, incoming suits எல்லாம் stay. Company cannot deal with the property. Company cannot deal with the property. இப்போ இங்க என்ன தெரியுமா இருக்கும்? Liquidation order pass பண்ண உடனே என்னைக்கு ఏ రోజు అయితే NCLT రిజెక్ట్ చేసి రెజల్యూషన్ ప్లాన్ moratorium stands extinguished. That's it. இந்த moratorium இருக்காது இன்னும். Moratorium எப்ப ஸ்டார்ட் ஆகும்? At the time of admission of your application. Now your process has been rejected. Now immediately what happens? Moratorium, no order required. That moratorium, once it passes a liquidation order, moratorium stands extinguished. ஏன் தெரியுமா? இப்ப கம்பெனி ப்ராப்பர்ட்டி எல்லாம் விற்கணும், இவன் வித்தாதான் காசு வரும். மாரட்டோரியம் இருந்தா డీల్ பண்ண முடியாது. మారటోరియం ఉంటే డీల్ చేయడం అనేది కుదరదు. ఇప్పుడు ఏం చేస్తాడు? మారటోరియం స్టాండ్స్ ఎక్స్టింగ్విష్డ్. హీ క్యాన్ డీల్ విత్ ద ప్రాపర్టీ, హీ క్యాన్ సెల్ ది ప్రాపర్టీ, హీ క్యాన్ సెటిల్ ద లయబిలిటీస్. నౌ non-exhaustive list of powers and duties of the liquidator to ensure orderly completion of the liquidation proceedings. His power is unlimited. The entire thing is he will sell the company. So section 35(1) provides that again he is subject to directions of the adjudicating authority, the liquidator shall have the following powers and duties. Again, you have to submit your claims before the liquidator. Liquidator only. Right. First one is to verify claims of all the creditors. The creditors are yaar. Let it be a financial creditors. Let it be operational creditors. He has to verify all the claims. He has to verify the veracity of the claims. This is first. Second one, to take into his custody or control all the assets. Good. Next one is property, assets, property. Very good. Now, next one, effects and என்ன actionable claim அண்ணா என்ன actionable claim அண்ணா என்ன தெரியுது actionable claim அண்ணா என்ன எங்க வந்து இது in which subject as claim? It's a big term. Thoughts are very good. Transfer చెప్పాలి actionable claims. என்ன actionable claim అన్నా ఏమి నీ పేరే వేణుగోపాల నీ పేరేమి నాగభూషణ చెప్పు actionable claims கோர்ட் ஆர்டரா நமக்கு தெரிஞ்சதெல்லாம் ஒண்ணே கோர்ட் ஆர்டர் அவ்வளவுதான் அது என்ன ஆர்டரு அது என்ன ரைட் your right to sue actionable claims your right to sue you are having certain rights other person is having certain rights can be transferred right so to ఏ మల్లికార్జున శర్మ ఏమి actionable claims అంటే very good you are having a right to sue in the courts of law that right to sue can be transferred company கொத்த மேல கேஸ் போற ரைட்ஸ் இருக்கு இப்போ அந்த ரைட்ஸ் யாருக்கு வரும் லிக்விடேட்டருக்கு வரும் company is having a right to sue certain person so that's what it's a big terminology right you are having certain company is having certain right that right has been transferred to whom யாருக்கு ஒரு ரைட் இப்போ very good liquidator இல்லன்னு நினைச்சுக்கோ if you want to transfer your actionable claims it should be by way of a registered document இங்க வந்து registered document தேவையில்லை by virtue of the liquidation order itself liquidator will get the rights మీకు అర్థమవుతుందా if you want to transfer your actionable claims registered document should be there இங்க தேவையில்லை liquidation order pass பண்ணா that itself is sufficient that he is getting the rights whatever be the rights the company is having over other persons that's it that means கம்பெனிக்கு எந்த ரைட்ஸ் இருக்கோ கம்பெனி மேல எந்த ரைட்ஸ் இருக்கோ எல்லாமே யாருக்கு வரும் லிக்விடேட்டருக்கு எப்படி வரும் லிக்விடேஷன் ஆர்டர் செப்பரேட் ஆர்டர் தேவையில்லை once the company gets the liquidation order itself the liquidator will get the rights by way of operation of law there is no separate order there is no order by virtue of the liquidation order itself you will get all the rights right this is the beauty of the law this is the beauty of technical speaking so actionable claim rights kuda eviki vachchestundi liquidator ku vachchestundi order undi ante vachchestundi automatically anni rights vachchestayi whatever the company can exercise he can exercise that's it against all the persons right now to take into custody or control all the assets property effects and actionable claims of the corporate debtor he will get all the rights previously who is getting the rights interim professional he cannot deal with the property he can only solve your things but here he can sell the property that's why he is taking into custody right to evaluate the assets and property of the corporate debtor assets and properties in the manner as may be specified by the board. Board means Insolvency and Bankruptcy Board of India, and he has to prepare a report. Statement of affairs, information memorandum, he will prepare a report, make. Again, the report prepare panenga kodukuno, adjudicating authority kodukuno dirapiyam. To take such measures to protect and preserve the assets and properties of the corporate debtor as he considers necessary. Such measures he will take to protect and preserve the assets and properties of the corporate debtor. தூங்குறான் பாரு அவன் பக்கத்துல. அவன் பேர் என்ன சொல்லு? உன் பேர் என்ன? ஏன் வேண்டாம்? But I can remember your face, don't worry. Right. Next one. To carry on the business of the corporate debtor. He can carry the business. Business means ఎంతవరకు డబ్బులు రాబట్టుకోవడానికి, for its beneficial liquidation only. Here, if any shareholder has to pay amount to the company, he will ask the shareholder. If anybody has to give money to the company, he will issue notice, please pay the company amount. Why? I am going for liquidation. డబ్బులు రావాలి అంటే అందరి దగ్గర ఇష్యూ చేసి తీసుకుంటాడు. Subject to section 52, to sell the immovable and movable property. Immovable property he will sell, movable property he will sell, and actionable claims of the corporate debtor in liquidation, right, by public auction or private contract, right. He is going to sell all the properties. Why? He wants to settle the liabilities of all the stakeholders and submit a report to NCLT that he has cleared everything. Once a report has been submitted, NCLT passes a dissolution or winding up order with the power to transfer such a property to any person or body corporate, or to sell the same in parcels. ஒரே வாட்டினாலும் விற்கலாம். கொஞ்சம் கொஞ்சம் parcel means we have pieces. He can sell the same in pieces, right? Provided that the liquidator shall not sell the immovable and movable property or actionable claims of the corporate debtor in liquidation to any person who is not eligible to be a resolution applicant. This is very important. He can sell to anybody, but he shall not sell to any person who shall not be eligible to be a resolution applicant, right? Subject to section 52, to sell the immovable and movable property and actionable claims on the corporate debtor in liquidation by public auction or private contract with power so and so, right? Next one is, if you remember one word, contributories. Companies Act, contributories. கேள்விப்பட்டியா? Companies Act யார் சொன்னா உங்களுக்கு? நாங்க தான் சொன்னேன். List A contributories, list B contributories. You heard. Contributory means whoever has to contribute to the assets of the company in liquidation. Contributors கிட்ட காசு கேட்க மாட்டேன் நான். எப்போ காசு கேட்பேன்? లిక్విడేషన్ வரும்போது கேட்பேன். ఎప్పుడు అడుగుతాను డబ్బులు? లిక్విడేషన్ వచ్చేటప్పుడే అడుగుతాను. దే ఆర్ నోన్ యాజ్ కాంట్రిబ్యూటరీస్. దట్ మీన్స్ you are taking the shares from the company. It's nothing but an agreement. For example, 10 rupees share is there. 10 rupees share is there. You are purchasing 10 rupees for whatever it may be. Premium. Now discount is not there. There is no discount on shares. Premium. But assume the discount is there. 10 rupees shares you can purchase for 8 rupees. 10 rupees share you can purchase for 15 rupees. That is the price you are paying for the shares. In the share agreement, the company is telling, in the event of winding up, you have to contribute to the assets of the company. You understand? In the event of winding up, புரிஞ்சுதா இப்ப contributors என்ன 10 ரூபாய் ஷேர் நீ வாங்கிண்ட இந்த ஷேர் அக்ரிமெண்ட்ல ஒரு கிளாஸ் இருக்கும் என்ன கிளாஸ் இருக்கும் ஒருவேளை கம்பெனி வைண்ட் அப் ஆனா கம்பெனிக்கு நீ காசு கொடுக்கணும் contribute to the assets of the company. It is not necessary now that you have to pay the amount. Or yes, at the time of liquidation only. They are known as contributories. List A contributories, list B contributories will be there. Again, they will be paid at the last. Now understand, contribute to the assets of the company during the liquidation, right? To take out in his official name, letter of administration. You know the meaning of letter of administration. Terima, letter of probate, letter of administration. When you are taking letter of administration, letter of administration telsa deceased estate. When person dies without appointing any person, his estate will be taken over by the courts by way of letter of administration. ఒక వ్యక్తి చనిపోయినాడు అంటే అతని ప్రాపర్టీ ఎవరు అడ్మినిస్ట్రేషన్ చేయాలని చెప్పి ఎవరు డిసైడ్ చేస్తారు కోర్ట్ లెటర్ ఆఫ్ అడ్మినిస్ట్రేషన్ హియర్ టు టేక్ అవుట్ ఇన్ హిస్ అఫీషియల్ నేమ్ లెటర్ ఆఫ్ అడ్మినిస్ట్రేషన్ టు ఎనీ డిసీజ్డ్ కాంట్రిబ్యూటరీ. Understand? That means if it takes letter of administration respect of deceased contributory, he can sell those assets. Technically புரிஞ்சுதா கான்ட்ரிபியூட்டர் இருப்பான் அவன் என்ன பண்ணணும் கம்பெனிக்கு காசு கொடுக்கணும் அவன் காசு கொடுக்கறதுக்கு அவன் எதுக்கான அவன் இல்ல எங்க போயிட்டான் அவன் செத்து போயிட்டான் ఇప్పుడు వాని ప్రాపర్టీ నేను అడ్మినిస్ట్రేషన్ చేయాలంటే పర్మిషన్ ఎవరు ఇవ్వాలి కోర్ట్ హ్యాస్ టు గివ్ పర్మిషన్ దట్ ఈస్ నోన్ యాజ్ లెటర్ ఆఫ్ administration. Deceased contribute, letter of probate, letter of administration to any deceased contributory and వాళ్ళు వస్తారు మళ్ళీ వస్తారు దే విల్ కమ్ మళ్ళీ అవన్నీ నెక్స్ట్ స్టెప్లో వస్తారు వాళ్ళు అర్థమైంది. ఇట్స్ ఎ ప్రొసీజర్ ఓన్లీ, ఇట్స్ ఎ ప్రొసీజర్. If deceased contributory dies without any legal heir, he will take letter of administration. If anybody is there, they will come. They will come. Legal representative లాగా వాళ్ళు ఉన్నారు. ఈ కాంట్రిబ్యూటరీ పేరు ఎక్కడ ఉంటుంది? షేర్ సర్టిఫికేట్లో ఉంటుంది. అవునా కాదా? వాళ్ళు చనిపోయినాడు అంటే ఆటోమేటికలీ వాళ్ళ పేరు మార్చేస్తారు అక్కడ. If any shareholder dies, what happens? His name will be there unless and until they will come and modify. Everything will be there, right? In his official name, any other act necessary for obtaining payment of any money due and payable from a contributory. Ungal kuda AC working, right? For you also you are getting AC now. You know, the main thing is not to relax, to hear the lesson. எதுக்கு ஏசி போட தெரியுமா? லெசன் கேட்கறவங்கன்னு சொல்லி போட்டா லெசன் கேட்கலன்னா திருப்பி எல்லாம் ஆஃப் தான் திருப்பியும், ரைட்? Yeah, please. Another 5 minutes is there. Let me complete this point. To take out in his official name, letter of administration to any deceased contributory and to do in his official name or any other act necessary for obtaining payment of any money due and payable from a contributory. Everybody has to give amount to the company. Let it be a shareholder, debenture holder, anybody, even contributory has to give money to the company, which cannot be ordinarily done in the name of corporate debtor, and in all such cases, the money due and payable shall, for the purpose of enabling the liquidator to take out the letter of administration or recover the money, be deemed to be due to liquidator himself. You understand? He is issuing the letter of administration as if the contributor is liable to pay to the liquidator. లిక్విడేటర్ పేర్లు అన్నీ ఉంటుంది, కంపెనీ పేర్లో ఉండదు. అన్ని ఎందుకంటే ఎంటైర్ అసెట్స్ లయబిలిటీస్ విల్ బి ద నేమ్ ఆఫ్ ద లిక్విడేటర్ ఓన్లీ. దెన్ ఓన్లీ హీ క్యాన్ సెల్. அப்போ நீ எனக்கு கொடுக்கணும்னு சொல்லி என் பேரு மேலதான் கொடுக்கணும், கம்பெனி பேரு மேல கொடுக்க முடியாது. You understand? Technically it cannot be given the name of the company. Why? I have assumed charge. Everything should be in my name. If it is company's name, I cannot sell. If it is in my name, I can sell. Everything should be in the name of the liquidator. Right? To obtain any professional assistance from any person or appoint any professional in discharge of its duties, obligations and responsibilities. Right? Next one, to invite and settle claims of the creditors and claimants and distribute proceeds in accordance with the provisions of the code. காசு வந்த உடனே எப்படின்னா அப்படி பே பண்ண கூட திருப்பியும் there is a specific order is there. The insolvency and bankruptcy code tells in this order only you have to pay money. You cannot what is called deviate from the order. நீ எனக்கு குடிச்ச உனக்கு ஃபர்ஸ்ட் காசு கொடுத்துறேன்னு சொல்லி கொடுக்க முடியாது. Suppose if you give that money, suppose if you give the money in overriding that payment, they are known as fraudulent transactions. Fraudulent transaction. திருப்பி அந்த மணி என்ன பண்ணுவோம் தெரியுமா? ரிகவர் பண்ணுவா திருப்பியும். லிக்விடேட்டர் வந்து ஆர்டர்ல கொடுக்காது, எப்படின்னா அப்படி கொடுத்தான்னு நினைச்சுக்கோ. Fraudulent preferred transaction, extortionate credit transaction, fraudulent preferences will come again. Again, it's a big procedure, right? Remain, we'll see tomorrow. Got something today? Right. Thanks. Universal code, unlimited jurisdiction. Universal code, unlimited. అది వేరే. అవును. In morning 9:30 కి వచ్చా. ఫస్ట్ అవర్ థర్డ్ అవర్ రైట్ మనకంటే రేపు నుంచి నిలవగా కంటిన్యూ చేస్తాం. సార్ వచ్చేవారు, సార్ వచ్చిన తర్వాత ఇఫ్ యువర్ కంటెంట్ ఇస్ డన్ యూ కెన్ డూ, అదర్వైజ్ మీరు ఎక్స్టెండ్
Yes, please be seated. I call all the students who are standing up to enter immediately. Quick, Rahul, ఎంతసేపు కావాలి? 10:50కే బ్రేక్ వదిలారు. ఇంతసేపా మీకు? రాహుల్, ఎస్. So, as a part of revision, I'll revise the rights of an advocate under Advocates Act. So, those who are absent at the time of regular lecture can now attend to the lecture. This is one stock question you get in the exam. ఈరోజు ఏం లేదా? కోర్ట్ అబ్జర్వేషన్, పోలీస్ విజిట్, పోలీస్ స్టేషన్, జైలు అన్నీ అయిపోయింది. జైలు అవ్వలేదా ఎప్పటికీ? ఇంకా ఇవ్వలేదు ఇంకా. సరే, yes, yes, be attentive. 6th row. Last 2 classes I warned you. This is the 3rd time. Yes. So in last class we have seen what are all the laws that are related to legal profession. Okay. And today we will see what an Advocate Act is. Guess I gave you some questions. Huh? Act యొక్క long title, object for passing the act. చూసుకొచ్చారా? Yes. Yes, at the end I'll go for the questions which I gave you. ఇంతకీ వచ్చారా రాలేదా అడిగిన వాళ్ళు? So, coming to the Advocates Act, you must be aware of the provisions of this Advocates Act. The act was passed in the year 1961. Have you gone through the provisions of the act? Last class లోనే చూసాము the laws relating to legal profession అని. There I included this Advocate Act also. So how many of you have referred Advocates Act? One. Only one. Good. The others are preoccupied with your own work, sir. Ugadi, Ramzan, relaxation. Sir. Huh? Relaxation లేదా? Yes. Okay. Do you find, Rohit, you have gone through the provisions of Advocates Act. Whether the provisions are apt and that suits the present day situation? Huh? not all the provisions. So you need certain changes to be done. Yes. So may I know few changes? Fee structure. What is that? You can use mic if you want. Yes. Ah. Mm. Demand చేయకూడదు. Mm. Mm. Yes. Conflicting situation. Minimum fee structure for an advocate so that he can fill his pocket. One thing. That's what. To to meet daily expenses, basic necessities. Mm. Okay. Mm. Okay. నామినల్ ఫీ స్ట్రక్చర్ అనేది అది వచ్చి ఒక ఫైనాన్షియల్ బూస్టింగ్ లాగా ఉంటుంది ఒక అడ్వకేట్కి అని అంటారు. ఓకే, దట్ యాక్ట్స్ as a స్టాండర్డ్ ఇన్కమ్. ఓకే. Exactly. When client is aware of the fee structure, స్టాంప్ ఎంత, కోర్ట్ ఫీ ఎంత, ఏమి మినిమం బేసిక్ ఇది తెలిసేదని అంటే ఈవెన్ అన్ అడ్వకేట్ హెసిటేట్స్ టు డిమాండ్ huge amount. He hesitates to demand a huge amount, but that is not known to, because many of the clients, ఇప్పుడు తిరుపతి తీసుకున్నామనంటే clients come from different remote areas in and around Tirupati. So they may not be aware of all the expenses, legal expenses. Practically not possible to bring a standard fee structure. High court, see, when you go to a high court, yes, an advocate is using his intellect. He is using his intellect, man. And so he can, if you want to get it done through him within inverted commas, then you must be ready to pay whatever the amount he demands. No advocate gives assurance, okay? Later on he will be. So no advocate gives assurance. Even if it is a genuine case, there is a situation of genuine winning or losing, whatever it is, an advocate will not. Yes. So now we will see certain rights of an advocate under Advocates Act. Right? Yes. Only if you concentrate, you can see the slide. Your brain I must coordinate. Look at the slide, then only you can understand. If you want, you can note down. Rights of an advocate. So, you are an advocate. Presume you are an advocate. So, what are the rights you have against the other? What are the rights? Generally, I usually tell students that when you are when you are studying something, presume yourself as a part of the situation. Okay, so as an advocate, what are your rights? What do you expect? Advocate at a practice cheyalna, you have a right to practice. You have a right. Whether the right is with restriction or without restriction is another question. In your terms, whether the right is an absolute right or a limited right. Is it an absolute right? Right to practice? No. Right to practice. Is the right an absolute right or a limited right? A right with certain limitations, restrictions or so. Subject to restrictions. So, if you can know the restrictions, then it is easy for you to. If you don't come under the restriction category, then your right is absolute. That's all. And then simple. So, let us see. Right to practice while studying the law, and the laws must be in consonance with the constitutional provisions, because constitution is a grand norm, it is a base. So the laws must be in consonance with the provisions of the constitution. Only if it is guaranteed by a constitution provision, then only the right is said to be valid, enforceable. And so right to practice is also a fundamental right. Right of an advocate to practice, which has been guaranteed under which article? Article 19, 191G. Okay. And right to enter any court. You are an advocate. You have a right to enter any court hall. Any court hall. You are not restricted to PS Jekmatiga Meru or family court Matige. You are allowed to. Any restriction on that? No. Because as an advocate, you can deal with, you can entertain any sort of cases. And so you have a right to enter the court hall, any court hall premises, and observe any live proceedings. You are permitted to. That is your right. What if someone objected you? If situation arises that you have been objected to watch the live proceedings, what will you do? అర్థమవుతోంది అసలు. Imagine you are sitting in a family court. Best example I will tell you, family court. ఎందుకంటే ఫ్యామిలీలో అందరు చదివినారు కాబట్టి బ్రహ్మాండంగా చింపి జీర్ణం కూడా అయిపోయింది కాబట్టి ఐ విల్ ఆస్క్ యు వన్ థింగ్. ఓకే, you are dealing with a family matter. You are representing your client. You are in a family court. You have been objected to watch the live proceedings of the case. When such situation arises, In camera. Yes. What is 164? Ah. Mm. 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 And so, okay. So in camera, when judge pronounces in camera, everyone have to come out. You are not permitted to. There you can you exercise your right here? I have a right to enter the court hall, and that has been assigned by, that is recognized by constitution itself. No. There your right is restricted, limited in such situation. Okay, coming to the next one. Right to freedom of speech and expression. Right to freedom of speech and expression. What is it? Whether your freedom to express whatever you feel, whatever you think is absolute. Again, that is a right with restriction, a reasonable restriction. Avuna? So, your right to practice is not an absolute right. దీంట్లోనే తెలుస్తోంది మనకు ఒక్కొక్కటిగా whether it is an absolute right or no. Freedom of speech and expression. Can you give an example for that? Huh? POCSO cases. Hmm. Okay. అది ఫ్రీడమ్ ఆఫ్ స్పీచ్ అండ్ ఎక్స్ప్రెషన్ ఎందుకు వస్తుంది? ఓకే. ఎనీ అదర్ ఆన్సర్? సెడేషన్ కేసెసా? ఎస్, ప్లీజ్ ఎక్స్ప్లెయిన్, షేర్. ఇక్కడ ఎవరు తెలిసిన ఒకరు కదా, అందరు పాత వాళ్ళమే. 3 ఏళ్లుగా చూస్తూ ఉన్నాం ఒకరినొకరు. against government, so you are not permitted to, but in practice it is happening. Open ga live istunaru. Illustrate with a situation. Okay. Okay. Advocate ga asalu cheyane cheyakuddu. This is not a general right to freedom of speech and expression. As an advocate, you have a right to freedom of speech and expression. But to what extent that right is enforceable and in what situations that particular right is, we can say, suspended. You cannot enjoy the right of freedom of speech and expression. Just one situation. Witness character assassination. Victim. While cross-examination, you cannot. వాళ్ళు చేసేదే దానికే కదా, అలా చేసైనా వాళ్ళు నిజం తెప్పించాలనేసి క్యారెక్టర్ అసాసినేషన్. ఓకే. We are seeing rights of an advocate. So one right is right to freedom of speech and expression. So in what situation this right is curtailed is my question. Yes, limitation. Strike. Right to strike is not a right. Inka degrading the judge, never permitted. Not even thoughts. మనకి అడ్వకేట్ రాకూడదు జడ్జిని లో చేయాలి వాళ్ళ యొక్క డిగ్నిటీకి అసలు ఇట్ షుడ్ నాట్ కమ్ టు అవర్ థాట్స్ ఆల్సో, మైండ్కి రాకూడదు. ఇంకా ద నెక్స్ట్, యూ జస్ట్ థింక్ వీఆర్ డిస్కసింగ్ ద రైట్స్. సో బ్లైండ్గా రైట్స్ మట్టిగా కాకుండా వెన్ ఈచ్ రైట్ ఇస్ curtailed at one point of time, మిగిలిన టైంలో అంతా రైట్ని ఎన్ఫోర్స్ చేసుకోవచ్చు. ఏ టైంలో చేయకూడదు అనేది మీకు తెలిస్తే సరిపోతుంది. వాట్ ఈస్ ద అదర్ నెక్స్ట్ రైట్? Is it not your right to meet your client in jail? Who is in jail? Accused? Accused అనే అంటారు, లేకపోతే only accused. Accused is under trial business. What is the difference between under trial and accused? Under trial and accused. Accused under trial అంటే under trial, simple, under trial, he is under trial. So when trial starts, only 5-6 students are answering and the others are why? వస్తాం మళ్ళీ స్టాండర్డ్ ఫీజ్కి వద్దాం. ఇదియా? ఓకే ఓకే సరే చెప్పండి. ఫీల్ ఫ్రీ టు షేర్ యువర్ ఆన్సర్స్. ఫీల్ ఫ్రీ. నేనేం తిట్టను కొట్టను. దిస్ ఇస్ ద లాస్ట్ ఛాన్స్ యూ హ్యావ్ టు ఇంటరాక్ట్ విత్ యువర్ టీచర్స్. దాదా మీరు మాట్లాడడానికి వచ్చినా మేము ఫ్రీగా ఉంటాం. దట్స్ ఎ డిఫరెంట్ థింగ్. ఓకే ఎస్. వాట్ ఈస్ ద రైట్? 10 minutes. చెప్పండి. ஃபிஃப்த் ரோ. நீதான் கவுண்ட் பண்ணிட்டு இருக்க. 1 2 3 4 5 நான் தான் நீதான். Yes, tell me. As an advocate, you have a right to meet your client. Do talk everything regarding the case and all, right? You have that right. Whether your privacy is curtailed there, is your privacy curtailed? How? How? Tell me, Devendra. How? You are meeting your client at the jail and you are discussing something regarding the case and all with your client. So do you think if someone comes and objects, time again, sir, will buy the running chapachna? Can a police interfere the communication? What is the time limit? These are all the practical aspects you must know. ఎంతసేపు పర్మిట్ చేస్తారు? How long an advocate can communicate with the client, with his client in the jail? Is it for 10 minutes, half an hour, or 1 hour? Is there any time limit? Yes. Then what is the limit? What is the limit? You have to answer. You can answer me in later class. No issues. Okay. And coming to the next one, right to refuse a case also. If you are not interested to deal with the case, to take up the case, and you are not so confident to try the case, whatever it is, to prepare the brief and all, then you are at liberty to reject a case. అడ్వకేట్ అయిపోయినారు కదా, మీరు ఖచ్చితంగా కేసు తీసుకోవాలి అంటే నో. సో దెర్ ఇస్ నో హార్డ్ అండ్ ఫాస్ట్ రూల్ దట్ యూ మస్ట్ యాక్సెప్ట్ ద కేస్ If you are not comfortable, you can refuse the case also. That is your right. Right to accept a case, right to refuse. That goes mutually. And what is the next one? Tomorrow I will continue this rights and all. Okay.
सवाल पूछ लेना मैं
processes are there, so many processes are there. Process also one, not one process, there are so many processes are there. You can write resocialization process also, process also, correct that one, process also write that. When you will find so many processes provision, you can write that, no problem. Okay, thank you. Welcome to this session where we stopped yesterday. Let us learn the unlearn things with this idea. Let us go ahead. Those who are interested, listen. Those who are not interested also listen, don't disturb others. Okay, today we will discuss two important topics: resocialization process, and another one is probation. The Probation of Offenders Act, we will discuss what are the provisions are there, what are the provisions are there, and who are eligible for this probation, what are the grounds of probation, we will discuss. So kindly cooperate with us, don't discuss. I know the mentality of our students. After that also it is my sincere appeal to all of you, please kindly have patience and listen. Okay, one. Hello, hello. What was it? What was it?
2000 ଦେଖ ହେଲା 2000 ପଠେଇଦେଲି ଦେଖ
Sorry for inconvenience caused to you. Let us continue our discussion. Resocialization process. Before entering to the subject matter, we should have a knowledge about what is socialization. Then we will understand, we'll analyze, we'll define, we'll explain the concept, the idea behind this resocialization process. So what is socialization? Then resocialization. What is socialization process? Yeah, yesterday I told. Yesterday, what is that resocialization process? Resocializations and socializations. Socializations and resocializations. So when we are here, we have been taught by our parents, the society. Let me tell you, the family is the primary agent of our socializations, isn't it? From our childhood, each and every moment of our life, the development of life, we are learning something. What is that learning? That learning is in society, whatever the good things you are receiving from others, that is the socializations. That is socializations. So family is the primary agent of socializations in the society. When we took birth, our parents, our relatives, they will teach us, Nana, do this, do that. This is not acceptable, this is acceptable. You are shouting here, this is not acceptable. Disciplinary, we believe in discipline, so follow the disciplinary policy, that is socialization. We want to make you understand what is acceptable and what is not acceptable. It's a part of socializations. Okay, so socializations. So what socialization means, the primary, who is the primary institution? So family is the primary agent of our socializations. Because first we are receiving the being trained by our family members, isn't it? So this human needs social experiences to learn their cultural, societal norms and values, customs, traditions in the society. We want that. Since time immemorial, our parents, grandparents, they are following some social customs. We have to also follow that. We have to carry forward those traditions, those customs, those societal norms, values for future also. So we need that. We need that social experience to learn their culture and to service. So in sociology, this idea, as I told you that criminologists like Edwin Sutherland, Caesar Beccaria, Donald Taft, and and they gave this idea. Not you. You are not criminologist. So they gave this. They borrow this idea from where? Sociology. So in sociology, you will find this socialization and resocialization process. So in sociology, what they mention, socialization is the process of learning or to understand, to inculcate, to adopt what? The societal norms, the societal values, the societal ideas, norms, social customs, our traditions, our beliefs, our thoughts, our expressions, etc., etc. It's not it. So, in sociology, so socialization's process is to learn something, to learn or to internalizing, to adopt. Internalizing means to adopt, inculcate, accept, or to understand the societal norms, the societal values, and the ideologies, the idea, the expectations of the society. What is the expectations of the society? What is the expectations of the society from us? Be good and do good. अच्छे काम करो, अच्छे से जियो. Live and let live. खुद जियो, दूसरों को जीने दो. You have no rights to disturb others. Morning we found that students are knocking door, final semester students. What is the meaning of disturbing others? There is no meaning of disturbing others. अच्छे से आओ, attend करो and चले जाओ. Don't disturb others. So this resocialization, what is this? It's an understanding to understand what the societal values, societal norm, what the society wants from us. What the society wants from us. The society is always there to guide us. Do good and be good. Don't accept that's the bad things. Don't follow the which is rejected by the society. It says that. So this socializations essentially it represents the whole process of learning throughout the life, each and every moment of our life, each and every day, each and every moment of our life, we are learning something from the society, from our neighbors, from our friends, from our teachers, etc., etc. So that is the it's a learning process. It's a process. So a learning process which represents the whole process of learning throughout the life and is a central influence of the our behavior. It affects our behavior in the society because when we will receive the good things, we will behave accordingly to the others. Isn't it? Isn't it? So, and actions of others as well as of children. These are the forms, as I told you yesterday. These are the forms or the types or the classifications or the types of socializations. One is primary socializations. Second one is the secondary socializations. Third one is that the anticipatory socializations. Anticipatory socializations, what you are accepting from the society. Socialization. Then the our topic as per our prescribed syllabus, resocializations, and the next one is organizational socializations. Then the last one is gender socializations. Sometimes this gender socializations also is known as gender sensitizations. So many authors they discuss gender sensitizations, how to behave the opposite sex, how to behave others, being a gender. No, you should behave properly to the other parts, to the other gender. That is the idea behind this gender sensitizations or gender socializations. Is also this gender socializations is also known as gender sensitizations. Now the Ministry of Women and Child Welfare, they are organizing gender sensitization program in school, colleges, university also. Gender sensitization program. So this, as per our prescribed, these are the types of socializations, and as per our prescribed syllabus, let us discuss about the resocializations. There is a topic, resocialization. Long questions will come, explains the concept or the rationale or the philosophy of resocializations in India. You have to write that long questions. Resocialization process. Okay, so let us discuss about what is resocializations. We just now we got an idea about socializations. Now resocializations. What is resocialization? Why they gave this call and why called it? They called it the resocializations. Why they called it resocializations? Already we are socialized because we are in a civilized society. We know what is socialized. So re-socialization means what? When you will shift to another place. When you will shift to another place. When you will go to another place, you have to adopt, you have to accept, you have to receive their culture, traditions, societal norms and values, not yours. So for a prisoner, in this penology and victimology, this is why they discussed here that they introduced this idea, they introduced this topic for prisoner, for prisoner, because when they will enter to the jail, during that period, they will accept, they will receive the what is the rules and regulations inside the jail. That is resocialization. You have to adopt. You cannot say no. I was free there. Why you are sending me before 6? You have to complete your meal, dinner. After that, you will enter. You cannot complain. You cannot say that after 6 I want my rice. Kindly give. Not allowed. It's a part of resocialization. You have to adopt. You have to inculcate. You have to accept that process. Resocialization process. This is a part of our resocialization. You have to accept those societal norms, rules and regulations, what as per the prescribed by the statutory provisions, law of the jail manual. They have their own law jail manual. So as per that guidelines, you have to adopt that. So resocializations, what it refers to the process of this also socializations and resocializations. What you will find, it is the process of learning something, the new idea from the society, new idea, new ideology, new beliefs, new thoughts, new concept, new notions. You will receive that, you will accept that, you will learn that. So resocialization is a process of learning and the adapting to new rules, customs, and the values and the expectations in society, just like your socializations. Okay, so coming to the process of resocializations, is typically involves the considerable stress for the individual, much more than anticipatory socialization. What is anticipatory socialization? As I told you that you cannot claim, you cannot ask them, no, I want my dinner after 9 because it's my habit. When I was there in my home, I used to have my dinner night at the night after 9:30. So here also give, no, that is not acceptable. That is because whatever the jail manual says that accordingly they will serve food. Now today Sunday I want chicken curry. Chicken curry not allowed, Nana. You will the rice and dal. Pappu, it will be available here. That is not available. You cannot claim that. You have to accept that. So this resocialization is a part of this things is a part of your resocialization process. You cannot claim. No, I want AC. AC is not allowed. Fan only. Blanket not allowed. Only plate you will get. Not this banana leaves food. Only one plate is there. You have to like that. So we visited this jail. You might have learned so many things, the unlearned things, what is going on inside. That is another issue. I am not entering that subject matter. Okay. So come to this. Jail visit. Not yet. You will learn there. Okay. They will not disclose, but because our security guard will be there, they will. You have no right to ask anything. Only you will observe what is going on inside. Sanitations, food, clothing center, etc. etc. So it occurs. This resocialization process occurs when a person engages to a new life. Suppose you got a new job. Suppose you got a new job. You got a new life. Then you have to adopt that the norms of that these new job, the criteria, the eligibility criteria. These are the things they will give you the guidelines. 9 you have to enter and 5:30 you have to leave this organization office. So this it occurs when a person engages to a new life. But for a prisoner, what is the new life? New life inside the jail only. The premises itself. Isn't it? So, with new environment, new surroundings, new conditions, new culture, new rules and regulations, and with other inmates, new people, other prisoners, you have to accept that. You have to accept that. This is the resocialization process. As I told you that you cannot because you committed a crime. Now the judiciary they awarded the punishment and now you will serve the jail for 5 years. So for these 5 years you have to adopt the new rules, you have to accept the new people and with new surroundings, new environments. This is the resocialization process, isn't it? So what you will do when you will enter the jail, as I told you that you have to abandon, you have to discard your previous practices, previous learned the societal pattern. No, evening we used to go to Ramanathan circle with my friends to have tea coffee. That is not allowed here. That is not societal. You have to avoid that. When you once again you will come out, then you will allow to make friends. There no friends, no tea, chai, coffee, no chai, coffee. Okay. So this is the resocialization process. So what it said resocialization means you have to discard, you have to abandon your previous practices and accept the new rules. And accept the new rules. You have to adopt that. You have to avoid that. So that's why, so adopt the newly inculcated one as the transition into a new phase of life. As you are as you are accepting the new phase of life, as you are starting a new journey of your life inside the jail for 5 years or 3 years life. So the new behaviors are learned in anticipation of a future role. So that depends upon for your future, you have to learn the different rules and regulations inside the jail for future perspective. For future, so a convict a convict released from jail. So these resocializations, when you enter into the jail, another resocialization process what? When you will come out from the jail after sentence, after you will be released one day after 5 years, after 5 years or 10 years or 7 years, you will be released from the jail. Then what will happen? Once again, you have to resocialize because the 5 years no friendship, 5 years far away from your family members. Only one time, half an hour or 10 minutes, 15 minutes, you will interact with your advocates or friends, your relatives. So totally cut off from this societal life, this freedom. So what is it? Once again you will re-socialize. Re-socialize means when you will come out, you have to adopt societal. You will change how the society changed. Now this flyover, when you are here, flyover was not there. After 5 years, when you came up, flyover came. It's super. So these are the society changing with the changes of time, and you have to adopt that. When you will come out from the jail after jail terms, resocialize. So when you will enter resocialize, you have to adopt that resocialize process. When you will come out from the jail, you have to adopt this resocialization process. Resocialization process. So this understanding, getting used to change the public policies. The difference between there are two types of socializations. One is voluntary socializations, another one is involuntary socializations. What is voluntary socializations? What is voluntary socializations? Which is depend upon you. It's completely depend upon your choice. This it says about your rights. Suppose you went to some another place. There voluntarily what you will accept or not, you will decide. You will decide. Nobody will suppress you. Nobody will forcefully give you whatever the traditions or the customs is going. So sometimes you will see that people, sir, they are adopting now. They are, suppose I am not happy with this city life. I am not happy with this city life. I want a rural setup. I want to construct a very good building there and I will peacefully lead a life there. Isn't it? So that is the voluntary. I accepted that. So when I voluntarily accepted that socializations process, I will accept that. No complaint from my side. Because voluntarily I accept. What is involuntarily? Involuntarily process means forcefully you are inside jail. As I told you that I gave you an example. Inside jail, what? You cannot demand after 9 I will have my dinner or after 12 I will go to my bed. That is not acceptable. Involuntarily. No. You have to accept way for you. That is your where that is known as the involuntarily resocializations. Voluntarily, involuntarily. So this voluntarily resocializations happens when an individual willingly adopts a new norms or policy because he shifted to the another place. You cannot say in our village, these things used to happen. We used to playing cards up to night and that village, you have to accept that. If they will allow you, it's okay. If they will not, no, in our culture, we will not allow. You have to adopt. So this voluntary socializations happens. So when an individual willingly accept or adopts new norms or behaviors in order to fit into a new aspects of society. As I told you, you move to the from this city life to the rural life. You have to adopt. So, on another hand, what is this involuntary socializations? Involuntary socializations happens when an individual is forced by circumstances, forced by the environment, the surroundings, the situations to adopt to new norms or behaviors. As I told you that inside the jail, forcefully. forcefully as per the statutes, the norms, the regulations, or the jail manual. Okay, so in the case of a prisoner, adjusting life in a reformatory after being sentenced for a crime. So for a prisoner, as I told you that once when he will enter, resocialize, when he will come out, resocialize. A new life. He will enter into a new phase of his life. Isn't it? So that is also known as the resocialization process, but involuntary. Not involuntary. Now, this is about your resocialization process. Resocialization process also, other methods are there for jail inmates. As I told you, vocational training, they are providing vocational training also, computer training, library if you are preparing, or your education if you want to study, or if you want to pursue higher study, there also they will allow, you will submit your application form and you are allowed to write examination in there itself. So these are the different yoga, meditations, that farming they are taking. All these are the vocational training program is conducting inside the jail. Inside the jail, it's a part of the reformatory process. So that when you will come out, you will rehabilitate yourself in the society. As one of our senior friends yesterday, he asked that the rehabilitations after that, there no one is ready to provide loan. So when you will provide that, the government will provide the loan for rehabilitations, restoration of your life. Restore, how to restore your life? After 5 years, 10 years, once again he will come. And who will give you money? Who will give you money? No one is ready to give in because your record is not good. So that's why the bank will come forward to provide the loan. That the process is there. Process is there. That is the resocialization process, and some vocational training, as I told you that yoga, meditation. So all these processes are there. So processes are different. What he told that process, so many processes are there for resocialization. But resocialization generally, this is the resocialization because when you will enter a new phase of your life, you have to accept that societal norms, customs, the tradition, the beliefs, the idea, notion, etc. etc. It's a new social resocialization process. Okay, with this resocialization. Now, coming to the other chapter of our, this is a Probation and the Probation of Offenders Act 1958. 1958. The Probation of Offenders Act. Probation. There are 3 P's. 3 P. What is that? One is probation, parole, and pardon. Pardon. Isn't it? 3 P's are there. The court will allow on probation. Go. Have a quality time with your family members and come. Probation, parole, and another one is 3P, pardon. 3 P's are available. So let us discuss about what is the meaning of probation. Probation, what is the philosophy or the idea or the rationale behind this probation, why they introduce this probation, this idea, probation, and what are the provisions. 3 things are important. What are the provisions under this Probation of Offenders Act 1958? We will discuss these 3 parts. So let us discuss what is probation. What is your idea? Can you enlighten us? What is your idea about probation? We have, because we know that being a law student, before we have also completed other degrees also, we have an idea about probation. The idea of probation. What do we mean by probation? And this is one type of, this is one type of resocialization, reformative process. Right. Right. It's one type of process, probation. So that, as I told you yesterday, what I told you day before yesterday, no man is born criminal. No man is born criminal. Who is then responsible? The society, the surroundings, the situations, the positions, the environments, and moreover, sometimes without our friends also. No, friend circle also sometimes, isn't it? So this is the things. Then that's why what Lombroso told that in his theory, the theory of crime, he explained. in his theory of explain what he explained. So no man is born criminal. It is the society. Something's happened with us. Immediately we'll react and give. The next day, where you will find inside Tirupati jail, isn't it? So this probation is a part of, as he rightly said, that probation is a part of our reformative process. Reformative process. So that why with this idea is that because no man is born criminal, certain happens with him, some situations compel him to commit that crime. Some situations, surroundings, environments, the positions compel him to commit that crime. So let us, because the idea is, let us correct. Because now, as I told you, that jail is not a jail but a reformation house or house of correction. House of correction. Jail is not a jail but a reformatory house or house of correction. So that's why there is no provision that now this government is, they constituted the committee, jail committee, they are visiting and they are recommending that the condition, there is no proper hygienic condition, they are not getting proper food, overcrowded prisoners. That's why the concept from their open prisoner, whose conducts are good and the conducts they are changing. They will observe. They will observe that his conduct is, they will monitor. His conduct is good. So let us send him to the open prison. Open prison concept is also there, where he will freely move, not on the road. Inside that, no handcuff, nothing. Nowadays, no handcuff, but you will open prison systems came to reduce the overcrowding inside the prison. So these are the idea, reformative process. So going on by recommending the different jail committee, they are recommending. So this, on the basis of that only, one jail committee in 1957, the government of India constituted a committee to recommend regarding this. That committee recommended regarding this provision. So let us have a look. Let us discuss about what is provision and what is provision and what is the idea behind this provision, what is the concept, this idea, the rationale, the philosophy behind this provision. Let us have a look towards this. Okay. So this, what is provision? What is provision? The provision is a conditional release of an offender. Regarding what? Regarding, as I told you, that they will monitor your behavior is now changing. Now you are changing yourself inside the jail by adopting new rules, new policy, new idea. So they will observe that. So on the basis of that, the jailer or the jail authority will recommend to the government of your concerned state. They will examine your conduct. The provisions are there. I will discuss what are the provisions under this Probation of Offenders Act 1958. We'll discuss. So let us discuss about what is the meaning of this probation. So probation is a conditional release. Conditional release of an offender or a wrongdoer under supervision. Under supervisions, you have to. They will say that what is that condition? Though we are allowing to allow you to go from jail, but every evening you have to give your attendance nearby your police station. Nearby police station. You are not allowed to go abroad. You have to surrender your passport. You have to surrender your passport. Everything. These are the provisions which is laid down under this Probation of Offenders Act, which says that provisions under which basis who are eligible to get this provision. Who are eligible to get? If you study the sections, all sections are there. So this provisions is, please remember, this provisions is nothing but a conditional release of an offender under the supervision. Under the supervision for what? For maintaining good behavior inside the jail. When you are there, your behavior is good. Your behavior is good. So that's why on the basis of that, the jail authority will recommend for probation, so that you will not commit any crime. If you will commit any crime once again, they will immediately, police will go, file another case and you will say, no further probation, parole, and parole. Gone. So this is the, so this correctional, this is one of the, as he rightly said that, this is one of the reformative. A correctional device is being increasingly used by the magistrates in modern times now. What? Because the idea is that one is, what is that? To reduce the overcrowded inside the jail, and on the basis of second idea is that because his conduct is good and now he changed a lot inside the jail, so let him allow to maintain that relationship with his family members, so this were the, it provides for early reformation, so and resocializations of criminals while they remain in the communities as ordinary citizens. The meaning of probation is, in Latin, is probare, meaning which means to prove. What to prove? Who will prove? Who will prove? You will prove. Because I am the wrongdoer, I am an offender inside the jail, I have to prove myself. Now, as I changed a lot and my conduct is now good, you have to prove. You have to show. No, I am. You have to prove. You have to prove yourself that you are a conduct. Now your conduct is acceptable. I will not repeat the same crime in the society. My conduct is good. So you have to prove. So this Latin, this word, the probation comes from the Latin word probare, which means to prove. Who will prove? Now you are worthy for release. Now you are worthy for release. So you will show your good conduct. You have to prove, no, and now I am okay. I'm just like a as usual normal human being. I will not repeat the same thing. So they will monitor that. So to prove. So under the provisions of provisions of Offenders Act 1958, these provisions are specifically applicable on offenders who have committed minor crimes for the first time. For the first time, they will go there, minor crimes for the first time crime coming. Okay, no problem. Situations compel him to do this crime. Friends are night, they sat together and friends are chalo, allow kar do probation. So this is the things going on. Then, so Donald Taft, one of the renowned criminologists, Donald Taft, what he said regarding this probation. So according to Donald Taft, probation is a method of treatment of offenders. It is the postponement of final judgment or sentence in criminal cases, giving opportunity to the offender to improve and readjust himself in the community. Because now that relationship cut off with his family members, there is no relation. So if we will phase wise send him outside the jail, he will slowly readjust himself in the society. And the society will accept him slowly. So according to Donald Trump, who is a renowned criminologist, according to him, this meaning of this probation, he said that, so community often on a condition imposed by the court. As I told you that there are conditions are there, you will not go without information, you have no right, you will seize your right to go abroad. You have to, if you are going to attend somewhere, you are changing your place, then you will inform your near police station under supervision. The court will put that supervision, that guidelines. So under the supervision and guidance of an officer of the court. Okay. Then as I told you that the rationale or the logic behind this probation. What is the logic? As I told you that no man is born criminal. With that philosophy, that idea, no man is born criminal. By keeping him inside the jail, we are making him a criminal. So this was the philosophy is that, the rationale is that, the logic is that, the idea, the concept behind this probation is that, underlying the probation is based on the assumption that most persons who become criminals, most persons, those who are committing crimes, regarding what? The situations, regarding the surroundings, The environment compels them to commit crime, to commit the crime. So this rationale is that the specials to do so because of their environment and the special circumstances, environments, the surroundings, the positions, the conditions, and that in suitable cases it is possible to change the conditions which led to a person's fall from proper standards and reclaim him as a sound normal citizens. He can, if we'll reform him, if we'll educate him, then he can, when he will come out from the jail, he will lead a peaceful life in the society. He will lead a peaceful life in the society, and he will lead the life as a law-abiding citizen. Law-abiding citizen. He will not commit any crime further. So the probation is a treatment, reaction to law breaking, and an attempt to mitigate. Mitigate means lessen, or the lesser the rigorous of the imprisonment. Because otherwise, if they continuously they will keep that, what will your brain will not develop. Always you will think that idea, the criminal idea, criminal tendency will come to your mind. So to lessen this rigorous this imprisonment, this idea, let us send him because he is now doing good. So on the basis of that, they will send him to the outside so that you will have a good relations with other family members, and after 7 days or 10 days or 1 month, you will come to once again, you will check. So that is the rationale or the philosophy behind this probation. Okay. So this another one is that is the so with this novel idea, the report of the jail manual committee, which was constituted in the year 1957. In the year 1957, the government of India decided to have a comprehensive legislations on probation of offenders. 1957, first time, the government of India constituted a committee, and they gave this report, this idea of probation. Let us send them on the basis of probation. Okay, so to accomplish this objective, a bill on probation was introduced in Lok Sabha on November 11, 1957. Okay, and the bill was referred to a joint select committee of the houses headed by Sardar Hukum Singh as chairman. Who was the chairman of that jail committee which was constituted in 1957 by the government of India? Sardar Hukum Singh. So they recommended this president. And sections 562 of the CRPC in 1891. Later on, it amended in 1973. Now this section 360 of CRPC deals with this probation, the idea of the probation. Earlier, it was under section 562 of the CRPC was the earliest provisions which dealt with probation. Now 360. Now 360 of CRPC and section 27. These two sections, it deals with this, the probation, this idea of this probation. So it was later amended in 1974 and became section 360. So in India, the provisions for probations are made under section 360 and section 27 of CRPC, and the Probation of Offenders Act 1958 deals with these probations. How to send that provisions under that. So in 1958, the Probation of Offenders Act was enacted with the objective of, what is the objective? The objective of empowering the courts to release an offender after admonition in respect of certain specified offences. Not for the death, or who are serving for death penalty or the life imprisonment, they are not allowed. So these provisions are there. Now coming to it, this committee proposed to empower to courts to release on probation in suitable cases, an offender found to be guilty of an offences not punishable with death or death and the life imprisonment. Please correct there. There is a mistake. Death and life imprisonment. So in case if the offender is less than 21 years of age or is a woman, the special provisions will be applicable for their probation, for their probations. If the an offender is less than 20 years of age, 21 years of age, and an offender is a woman, the special provisions will be applicable for their release on probation. So coming to, so in case of juvenile probationers, non-criminal procedure is adopted and it is less formal. In case of the juvenile probationers, in non-criminal procedures is adopted and it is less formal. Then the coming to the next, that is the basic purpose is to keep the delinquent, the juvenile delinquency, away from ill consequences of the imprisonment and offer him an opportunity to lead the socially useful life without violating the law. To reform him as a juvenile because he has committed the crime, he involved in a criminal activities. So to reform him, they will this, because that's why there is a for special provisions are there for juvenile delinquent, for the juvenile delinquent. Okay, now the provisions of the provisions of Offenders Act. Let us discuss about, what is the time now? 4 5 minutes. I will not take extra time, your valuable time. Let us have a look towards these provisions of the Probation of Offenders Act 1958. There are so many provisions are there, but these are the important provisions which is laid down under this Probation of Offenders Act. The one is, that is the court is empowered. As I told you that, what is the rationale? The committee empowered the court to release the offenders or the wrongdoer or the criminal on the basis of probation or what, for good conduct. So the here it is these provisions of the Probation of Offenders Act. The provisions, one is which is very important, that the court is empowered to release an offender of certain offences after admonition. What do you mean by admonition? Rohit, what do you mean by admonition? Sitting in prison, but giving a warning. It will refrain. Warning, certain warning. So this court is empowered to release an offender of certain offences after admonition as per section 3 of this Probation of Offenders Act 1958. Coming to the second provision, which is important, the court is empowered to release certain offenders, not all, on probation of good conduct. As I told you that the jail, on the basis of the report submitted by the jail authority, don't think they are not observing. They are monitoring how you are conducting, how your conduct behavior is good or not, or now, or you have still violent in nature, still violent. So they will, on the basis of that only they will recommend. Now very recently, the Gujarat government released, in that case, released 4 5 6 offender immediately. Who? Bilkis Banu. She immediately reported, filed a case, read petition before the Supreme Court under article. So it is completely illegal. They are the hardcore criminal. On which basis? Because they are relating to one political party. They are relating to one political party. On this basis of that only, they immediately Supreme Court rejected, signed. Isn't it? So this is the idea is that good conduct will be supervised or monitoring by the jail authority. So the jail authority finally they will submit a report to the court and to the Home Department for your probation, for the release of before, prior to that time, probation or parole or pardon. These are the three things are there. So the court is empowered to release certain offenders. The court is empowered to release certain offenders on probation of good conduct as per section 4 of the Act. So the persons when found guilty of having committed an offence not punishable with death or life imprisonment, and the court is satisfied that the offender should be given the benefit of probation, may release the offender. Second provision, section 4 of the Offenders Act, it clearly defines, it clearly says about the release of probation. What is the eligibility criteria when an offender is eligible for this office, for this probation. Section. Coming to the next provision, before making any probation, order of the court shall consider the report of the probation officer. Before making any probation, order the court shall consider the report of the probation officer. Because probation officer, every jail is having one probation officer. They will monitor. They will monitor. So the court will consider the report of the probation officer who has been appointed by the state inside the jail. He will monitor. He will stay with them. He will not inside the jail. He will monitor. He will monitor the probation officer. So every jail has their own probation officer. Every jail has their probation officer. So they will monitor. So on the basis of the report submitted by the concerned probation officer, the court will take a decision. The court will take a decision. Isn't it? So then the coming provision, then the next provision, the court shall assign a probation officer if necessary. If necessary, the court shall assign a probation officer under whose supervision the offender shall remain but not less than 1 year or and as specified in the order. The court will decide. Court will take a constructive decisions with regard to the release of an offender. So the offender, next point is, the offender shall enter upon with the court with or without sureties to abide by the conditions or the original sentence shall hold good. As I told you that the court will ask, submit your passport. You are not allowed to go abroad. You are not allowed to go to change your place without the prior informations of the court or the nearest police station. Suppose you are going to another place to attend your family function. You have to inform the police. And every evening you have to give the attendance where nearest police station. That is, the conditions will be applied by the court. That is, others also conditions are there. Other conditions are there also. And under section 6, under section 5 of the Act, the Provision of Offenders Act, the court is empowered to order the release of offenders to pay the compensation and costs. So these will be as the court finds fit and shall be recovered as a fine. Next, section 6 puts a restrictions upon the imprisonment of offenders under the age of 21 years. This is subject to certain conditions. The conditions are laid down. If you want the more with regard to more to make you for your better understanding, kindly refer the Provision of Offenders Act 1958, section 6. The conditions laid down in that act, in the statutory provisions. So the report of the probation officer is confidential. This report, you cannot, otherwise he may be biased because the political people is an influential people, or he will give money, and he will on the basis of nothing. So confidential, purely confidential. The court will monitor, court will examine. If necessary, court will appoint another person with her to verify because there are certain principles certain persons are there who are the hardcore criminal or influence to the jail authority for what? To get this, to avail this opportunity. So to check these irregularities, the court will monitor all these situations. Okay, and the another one is that the variations in the condition, last conditions, then we will stop. So variations in the conditions of the provisions, order can be made after considering the following conditions. The court will monitor, the court will examine, court will expound the conditions or the recommendations of the probation officer or the jail authority, concerned jail authority. On the basis of, they will examine what? Now, the offender and the surety or surety shall be given opportunity to be heard. Coming to the another condition, that is, if the surety refuse, then the offender shall have to enter a new bond. Suppose sometimes you cannot give guarantee. So whenever you are giving that bond to the court for the bail, please don't do that. If he will go somewhere, police will arrest fast the sureties. Nowadays, that's why sureties are not coming forward unless and until. Just sir, wait.
Okay, no, no, see.
Okay.
No, no, no.
And if the surety refuse, then the offender shall have to enter a new bond with another person. If not, then shall be original sentence. He will not allow to go outside. This is the condition. And the another one is the bonds can be discharged on the basis of report of the probation officer. Okay. The last one is that is the Section 9 of the Probation of Offenders Act 1958, which deals with or which says that the situations of the offender fails to observe the conditions of bond. In this case, if the court is satisfied to the failure of not observing the conditions of the bond, it may issue a warrant of arrest of may issue summons to him. Section 10. The court may issue summons or the warrant immediately, because they are now sometimes it is happening in the society, because once they will come out from the jail, once again they will involve in criminal activities. If the victim person informed to the court will immediately issue summons notice, inform direct to the police, immediately send him to the jail. Immediately they will stop. They will not allow further the what is the extensions of the time. Immediately sent to the jail. This sections 9 of the Probation of Offenders Act 1958, it deals with these provisions. Okay, so this is with this. Let me stop here for today. Another two topics are there: the victims in the criminal justice victim and the criminal justice system, and the another, as I told you, that 3P provision. Now we'll discuss about the parole system. Parole system, what is the provisions for parole system, how a persons will get avail this opportunity for parole system, what is the mindset of the judiciary, we'll discuss in our next class. So with this, let me stop here for today. We'll meet day after tomorrow with a new subject, new topic. Thank you. Thank you very much. Now, once again, I will invite my colleagues, my esteemed colleague, Professor Maglit sir. He will announce something for your benefit, I think. Not benefit.
Okay. Good afternoon. How are you all? Okay. I am here to give you some rules and regulations to be followed very strictly. I am here. Okay. Just listen carefully. See, because of your mischievous activities, our management is suffering a lot. Not only management, juniors are suffering a lot. And there are some points should be followed strictly from next class. That is, we have granted a grace period of 15 minutes in order to accommodate the transportation issues from Renigunta to Tirupati. அதாவது ரேணிகுண்டால இருந்து திருப்பதிக்கு வர பசங்க சப்போஸ் உங்களுக்கு ஏதாவது ட்ரெயின் இஷ்யூ ஆகி லேட் ஆயிடுச்சுன்னா சப்போஸ் 9:30 you should be here sharp 9:30. From next class onwards the gate will be closed. After 9:30 you are not allowed. Clear? Suppose உங்களுக்கு ட்ரெயின் லேட் ஆயிடுச்சுன்னா you have to show the ticket to our Chaitanya sir. Okay, you can give the explanation. Suppose train delays. Point number 2. Students who are residing in Tirupati are making misuse of this grace period. I have seen so many students who are residing nearby college. They are intentionally coming late. Many of the students who are residing nearby our college, they are intentionally coming at 10 o'clock. This should not be entertained. If so, you will be given absent. No grace will be shown. No mercy will be shown. அதாவது காலேஜ் பக்கத்திலே யார் யார் ரூம் எடுத்து ஸ்டே பண்ணிட்டு காலேஜுக்கு லேட்டா வரீங்களோ அவங்களுக்கெல்லாம் ஆப்சென்ட் தான். No excuse will not be given. Point number 3. Students must be present in the auditorium before 9:30 a.m. That means you have to be here in the auditorium 9:15 a.m. sharp. Before 9:30, I am repeating, you have to be inside the auditorium before 9:30 a.m. புரியுதா? அடுத்த கிளாஸ்ல இருந்து ஆடிட்டோரியம்ல 9:30 முன்னாடி அதாவது 9:15க்குலாம் you should be presented. Point number 4. Students should maintain silence in the staircase as it is creating nuisance for the other ongoing classes. நிறைய ஸ்டூடண்ட்ஸ் நான் இன்னைக்கு பார்த்தேன், எல்லாரும் படிக்கட்டுல வரும்போது உங்க ஜூனியர் கிளாஸ் டோரை லாக் பண்ணிட்டு வரீங்க. This is absolutely a nuisance. Don't laugh, man. Shame on you. நிறைய பேர் டோரை தட்டிட்டு வரீங்க. Next time if I notice anyone, you will not be given attendance. Not attendance. Final year, final attendance certificate வாங்குறீங்கல, டோட்டலா பிரின்சிபல் சார் உங்களோட அட்டெண்டன்ஸா பிளாக் பண்ணிடுவாரு. If you are indulging in such kind of activities, if you are disturbing your junior class, the matter will be taken very seriously by the management. புரியுதா? இன்னைக்கு பார்த்தா நிறைய பேர் ஒவ்வொரு கிளாஸ்ல போய் டோரை தட்டி ஓடுறீங்க. Don't involve in such activities. You will be punished severely then and there. And students should not use mobile phones inside the campus at any cost. From next class onwards, you are not supposed to carry your cell phone. Any emergency, you have to get permission from principal sir or the concerned teacher. 90% we will not allow you to use cell phone. If you are using cell phone, we will confiscate your cell phone immediately and your phone will not be given back. புரியுதா? உங்க செல்போனை பறிமுதல் செய்யப்பட்டால் திருப்பி தரப்பட மாட்டாது. புரியுதா? கண்டிப்பா தர மாட்டோம். Even in the staircase, if you are using phone or in the corridor, if we confiscate your phone, we will not show any mercy from next class onwards. It will be implemented right now. And finally, don't disturb your friends or classmates while the classes are going on. நான் பார்த்தேன் பிரின்சிபல் சார் கிளாஸ் எடுத்துட்டு இருக்காரு, பின்னாடி நிறைய பேர் chit chatting. Most of the students are chit chatting. Don't disturb those who are interested, man. If you are not interested, please leave the class. உனக்கு கிளாஸ்ல உட்கார பிடிக்கலனா போயிடு, absent அன்னைக்கு மார்னிங் செக்ஷன் you will be given absent. Go to your room and take rest. Don't disturb others. I saw many of the students are chewing bubble gum. Many students eating chocolates and throwing the wrappers. What is this? Is this a fish market, man? Just look at down. Many cool lip. Many guys are, particularly boys, are using cool lip. Very shame to see. They are keeping in 4 sides: upper jaw, lower jaw, and side jaws. And if we see any kind of activities, we are going to take severe action from next class onwards. I mean afternoon class from now onwards. Afternoon, it starts from afternoon class. This is going to be implemented right now. And many students are consuming alcohol and coming to college. Many students consuming beer and coming to college. This should not be entertained. It's a final warning for you guys. Already your names have been noted.
Dear students, consuming alcohol is your rights. We are not saying you don't consume alcohol. Choice is yours. But while you are consuming, don't come to college. It spoil our disciplinary policy. You have every right to consume alcohol. That is your choice. There is no restriction. But don't come. When you will consume alcohol, stay inside your room. Don't come out. That will doji. And also I will tell you that.
So சார் சொல்றாரு குடிக்கிறது என்னோட உரிமைன்னு சொல்லிட்டு குடிக்காது. ரோட்ல விழுந்து கிடக்கிறது, ஸ்ட்ரீட்ல ஆட்டம் போடுறது. சி டேய் எனக்கு வீடு பார்க்க போனேன்டா, வீடு தர மாட்டாங்கடா. உங்க ஸ்டூடெண்ட்ஸ் எல்லாம் குடிச்சிட்டு ஆட்டம் போடுறாங்க, எனக்கு வீடு எவ்வளவு தர மாட்டாங்க. நீ பண்றதால நான் அஃபெக்ட் ஆகிறேன். ஒருத்தரும் வீடு தர மாட்டாங்க. சார் உங்க ஸ்டூடெண்ட்ஸ் ரூம்ல எல்லாம் குடிக்கிறாங்க, சண்டை போடுறாங்க, உங்களுக்கு தர மாட்டாங்க. நீ பண்ற தப்புக்கு நான் என்ன பனிஷ்மெண்ட்? So take the matter seriously. Take the matter seriously. Hereafter, you will not be given any excuses. Okay. And another good news.
1 second, sir.
Many times I said the same thing. Please be quiet. Don't disturb the other person. Do your own business by yourself. People who are listening also are being affected by you. Maintain silence. That is the only request we are asking you. You guys are asking us so many requests, which we are trying to keep up. I see people who are sleeping, who are drawing in their books. Even then, I haven't interrupted them. The reason being, at least they are not disturbing the other person who is sitting next to them. Kindly maintain silence in the classrooms such that the people who are interested can at least focus on that. We have already convicted 2 people for whom we will not be issuing hall tickets because they have consuming this cool at all. So going forward, if at all I notice anyone using any tobacco products or consuming alcohol or even drugs, definitely their career is done then and there. Mobile phones, please don't come behind me requesting, because it is purely management's decision to take over their phones. Even after I'm reminding them to not to use the mobiles inside the campus as well, you guys are using it. You guys are only not following the rules, making your lives harder. Before it wasn't like that. This is the first and last. Going forward, please don't run behind the management. Use your brains and your focus. Thank you.
Tomorrow you have holiday on the eve of Eid Mubarak. Okay. So happy Ramzan in advance. Okay. So for honor students, you have class in the afternoon. Okay. So take the things seriously. Don't make fun hereafter. So you are about to complete your course. Okay. So take the things seriously. Don't argue with management. I saw many of the students are shouting with and showing your hesitation to the staff. Don't entertain such things. Here we are to guide you, not to exploit you. Okay. So now the time for attendance. Okay. See, morning some of the students caught by management, right? Those students should not come for attendance. Okay. You are not supposed to give your attendance. Rest of the students, you can give your attendance. Now, 5